Hey everyone, this is Shannon Villalba, the Multipreneur Lawyer, where law is not scary. Don't be scared by the language in your contract. Here's a tip about the governing law, jurisdiction, and venue provisions, which are typically found at the end of a contract, and why it is extremely important to review them before you sign an agreement. All contracts should have a governing law or choice of law provision within them. This provision allows the parties to agree that the contract is governed by the laws and regulations of a particular state or a country, even if they live in another state or country. For example, you might see language that states the following: this agreement has been made and executed in and shall be governed by the laws of the state of Ohio. Should a party wish to dispute any of the provisions of the contract, then Ohio laws and rules will be applied to determine the outcome of the dispute. Additional language regarding jurisdiction and venue are typically included as well, either as separate revisions or lumped in with the governing law provision. For example, you may see the following: the parties voluntarily consent to the jurisdiction of all federal and state courts in the state of Ohio, and the parties further agree and consent to the venue of any action shall be undertaken in Butler County, Ohio. Jurisdiction often refers to the location where the dispute will be decided. If parties are in two separate jurisdictions, the language will dictate that one of the parties will need to travel to the jurisdiction listed and consent to the laws of that jurisdiction. You might see how some corporations favor Delaware because its laws often favor corporations. If you live in Ohio and sign an agreement with Delaware as choice of law as well as choice of jurisdiction, you consent that the contract will be interpreted by the laws of Delaware, and you agree to be bound by those laws with regards to the contract and the proceedings. For example, if you file a lawsuit in Ohio for breach of contract, the case will then be transferred over to Delaware, and you will need to travel there and hire local counsel or have your lawyer pro hoc vice in to Delaware to participate in the case. So the venue provision establishes which courts have jurisdiction over the matter in a particular geographic location, like the city, the county, the state. While there are laws governing certain types of disputes, for example, real estate litigation occurs where the actual property is located, parties usually include venue clauses in every contract. Typically, companies choose a venue that has some relation to it, such as the city or county or state where the company is located in for a hometown advantage. So venue clauses can either be mandatory or permissive. Mandatory clauses dictate that a court of a particular city or county will be the exclusive court in which to determine the dispute, and uses the terminology will have exclusive jurisdiction. And permissive venue clauses typically use terminology that is may have jurisdiction. So when you were looking at the prior example that any venue shall be undertaken in Butler County, Ohio, the venue dictates that the case will be heard in any court in Butler County, Ohio, so it is a permissive venue clause. So why is the choice of law provision important? Well, when you're signing an agreement with a particular choice of law provision, you are consenting to the contract being interpreted by the laws of the state as listed, as well as availing yourself to the jurisdiction and venue which may or may not be convenient or favorable to you. So it is important to review the choice of law provision so that you understand what rights you may have giving up with regards to litigation. Should you have any questions, just feel free to reach out to me. Again, my name is Shannon Villalba, and I am the Multipreneur Lawyer. Have a fabulous day.